All right. Hello, everybody. My name is Timothy Scott, or TJ Scott, and I'm an estate planning attorney with the law office of Timothy J. Scott. That's me, Timothy J. Scott. It's my law firm, and what I do is estate planning. That means I help people to plan for after they're gone, or if they become incapacitated through something like dementia or an accident where they're in a coma before they're gone, helping them to plan for that possibility as well, so that their family is well cared for and that they have the simplest time in resolving the affairs as possible. I'm so happy to have so many people joining here today. In fact, if you're joining me here today, if you can find the chat box or the chat button and you can tell me where you're joining from, I would really appreciate it. I think I have some people joining from as far away as Alaska. I saw somebody registered from the UK, and I've had people join from the UK before as well. The UK, I believe, is 6 hours ahead of our time here in Minnesota, which is where I am. So 6 hours ahead would mean that they are joining at something like 1 o'clock in the morning. And so if you're joining from the UK, I'd love to hear that. Oh, you know what? You may not have the permissions to share. Let me just see what I can do about that really quick. You should see a Q&A box, and you should have the permissions to put things in that Q&A box, but I always forget. I think that there is a way to permit people to actually share their information. Gosh darn, now I can't find it. There we go. Attendees can chat with everyone. Perfect. And now you should be able to put in the chat box where you're joining me from. Apologies for that, but I should see it now. There is also a Q&A button where you can put your questions and I can answer those questions. See, somebody's joining from Waconia, Minnesota. Beautiful. I grew up in Chanhassen, Minnesota, so I'm very familiar with Waconia. Beautiful area. My grandfather grew up in St. Bonnie out there as well, so I'm very familiar with the area. Again, I'm so happy to have everybody joining me here today. It's great to have you here in the webinar. Again, I hope that you'll post where you're joining from. Sorry about that little snafu, but I'd really love to see. It's always very interesting to see where people are joining from. Today, I know we're going to be talking about something that's difficult. It is a difficult topic, but I want to give you knowledge and I want to give you power over this difficult topic. And that's what we're here today for. I'm here to give you knowledge. I'm here to empower you so that you don't have to be so concerned about this area of your life and this inevitability that we all face together. So I have some really valuable information to share with you. I also have some valuable offers I'm going to be making at the end of the hour here. So I hope that you'll stick with me until the end of the presentation. And the best way to learn with me today is to turn off any other distractions and give yourself this time. You already set this time aside. So please just give me your attention for a little while. This is dense stuff. It can be. I'm going to try and simplify it. I'm going to make it as easy as possible. In fact, I have some demonstrations I think you're going to like, or one that I'm particularly proud of. So please give yourself this time and give your attention to me. And I can promise you your future self is going to be glad that you spent the time here this evening educating yourself on this topic. And if you stick around until the end, I do have some wonderful offers that I want to make to you, including how you can get a free virtual one-on-one meeting with me to talk about the people that you love and the things that you have, and how you can protect those people and protect those things to make sure that they go the way that you want them to. Plus, I have a bonus gift that makes it even easier to get a personalized and tailored estate plan put in place. And I'm seeing a lot of people joining from Minnesota, and I see my friend from Alaska. Very nice to have you on the call here tonight. I'm glad that you're able to join this afternoon, because in Alaska, it's the afternoon, but here in Minnesota, it's the evening. All right, so the first question that I have for everybody is, do you have an estate plan? And I do see somebody has asked me a question, and so I'm going to put my attention there in just a minute. But before I do, I just want to talk about this. What is an estate plan? A lot of people say when they hear that question, they think a will. A will is an estate plan, or they think a trust. You know, you don't really have an estate plan until you have a trust. But the reality is these are just tools in an estate plan. Almost every estate plan is going to have a will, but it's not necessarily for every estate plan. That there are some ways that you can plan with beneficiary designations. Some people don't have sufficient assets where they exceed the small estate amount. Here in Minnesota, that amount is $75,000. So some people fall below that threshold and they don't have to worry about probate. They don't have to worry as much about their estate and how it's going to go to the people that they love. But most often it's going to include a will. It may include a trust. There are other ways to plan for your assets, and there are other ways to plan to avoid probate. But a trust is a good way to do that, and we'll talk about that here today. Guardianship nominations are important if you have minor children. Healthcare directive, power of attorney, those are documents for planning for incapacity before you die, and they actually go out of existence, or they are no longer valid and effective after you pass away. Then beneficiary designations, I mentioned a little bit. That's also part of an estate plan. And there's a whole bunch more that an estate plan can be composed of, or that can be instruments we're using in an estate plan. And I'll talk about some of those things tonight, but these are some foundational things that you might think of when you think of an estate plan. And when I ask that question, I'm seeing overwhelmingly, most people are saying, no, they don't have an estate plan in place. And if that's you, that's okay. That's what you're here tonight to learn about, and that's what you're here tonight to get more information about. And I'm really happy that you're here. And I know for a lot of us, let me see here, I'm going to go ahead and launch a second poll. And the second poll is, does one of these things on the screen resonate with you? Does something here ring a bell? That maybe you don't have an estate plan in place right now because you're too busy. And trust me, as a father of four and somebody who started their own business, a couple of businesses, in fact, I completely understand that life is very busy, life is very hectic, and it's difficult to find time in the day to put our attention on this. Or maybe you feel like you're too young and you look at my baby face, no, maybe not anymore, but once upon a time, I certainly looked young. And I felt like I was too young maybe to have an estate plan in place. And this is true for a lot of us, but the reality is anyone over the age of 18 should have some of those building blocks that I was talking about in the last slide in their plan, anyone over 18. And the reality is this, somebody goes to college and something happens, they end up in the hospital. Are mom and dad going to be able to talk to the doctors? That's a real question. That's a real problem that a lot of families have seen, and a lot of families have unfortunately had to face. With something like a healthcare directive, everything is much clearer. We know who the healthcare agent is then. We know that mom can talk to the doctors. And let's be honest, it's usually mom. We know that mom can make decisions about healthcare and about what is going to happen with that child. So there really isn't too young. If you're an adult, you need to have some foundational documents in place. And maybe you're worried about it being too expensive. And I do see a number of people who are saying that they're worried about estate planning being too expensive. And I understand, because oftentimes it means getting a lawyer involved, and lawyers tend to be very expensive. But there's good news on that front, that estate planning is more affordable than it has ever been. And truly, estate planning now is for the middle class. It's for everybody. And really, a big part of that is the advent of word processors. Things like Microsoft Word on the computer have made it much more accessible to everybody. You don't have to fill out forms in triplicate anymore. And if you make a small mistake, you have to tear up the entire thing and start all over again. No, now we have word processors. It's much more forgiving. And again, estate planning is really affordable and accessible for everybody. And everybody really needs some forms of estate plans in place. It's really important. Maybe you're worried about jinxing yourself. Oh, and I see somebody is fessed up that they're worried about jinxing themselves. Fair enough. And I understand. But I can tell you, as somebody who's been doing this since I graduated law school back in 2012, I have not seen any kind of correlation between somebody getting an estate plan in place and having something happen to them. You know, this isn't a sitcom. This isn't like the police officer who's going to retire the next day and something bad happens. Nope, it's not like that. Don't worry about jinxing yourself. In fact, I always say, I think that my clients, they walk out of my office with a weight off of their shoulders. They're more intentional with how they live. And so I think, if anything, that there's a correlation the opposite way, that they have less concerns, less worries, and more awareness of what's going on in their day-to-day. I did want to get to this question here, and my apologies and thank you for your patience for waiting for me to answer the question. Somebody was asking, I heard that if you have your house in a trust, but the new rules now are that a nursing home can still get your house for payments, even though in a trust. And this is a fantastic question. We'll definitely talk about nursing homes and nursing home care and cost and how we can protect the house. It's true that if you have your home in a revocable trust, a revocable living trust, which is a typical trust that's commonly done for estate planning purposes, well, then that house is still accessible for what's called estate recovery. At least here in Minnesota, it's still accessible for estate recovery. There's some rules in other states that change that a little bit. There are things like ladybird deeds, which allow you to pass the home without it having to be subject to estate recovery. But here in Minnesota, generally, if you're using that kind of revocable trust, or if you're passing the house by a will, or if you're using a transfer on death deed, however you pass the house, it's still potentially subject to that estate recovery. However, there are some ways to protect the house. There's something called a Medicaid Asset Protection Trust, or it's also sometimes called a 5-year trust. And having that irrevocable trust, so you can no longer make changes to it. It's kind of on rails once you set it up. There's no more changes can be made. But once you put a house into that and you wait out the 5-year waiting period, you can protect the home from something like a 5-year look back or estate recovery in the case that you receive nursing home care and have the state helping to pay for that nursing home care, and then the state is looking to recoup that from your estate and from your assets after you're gone. So yes, and that's been the way that it's been in Minnesota for a long time. In fact, we only gained the ability to write those irrevocable trusts in, I believe it was 2021, the summer of 2021, that a better court ruling came down that said, nope, those Medicaid Asset Protection Trusts truly do protect the assets inside of it, and it is no longer accessible for something like estate recovery or for a medical assistance application or a Medicaid application that you might be making here in Minnesota. It's a fantastic question. I hope that I answered it in enough detail for your specifics. If not, again, I encourage you to reach out to me at the end here, and we can continue the conversation together. All right, if you have a plan in place, or even if you don't have a plan in place, but something on here resonates with you, I want to know, what is it that you're hoping to learn here tonight? And I'm going to launch another poll here. You should see it live now. Maybe you want to learn, is an online or do-it-yourself will okay? Is it going to take care of my family? Is it going to take care of my estate in the way that I want my estate taken care of? Or maybe it's been a long time since you've done your estate plan or you've done a will, and you want to know, is it possible that that will is outdated now? Is it something that I need to update with some frequency? And I'll definitely speak to that. In fact, I encourage that you have your estate plan reviewed every 3 years, and maybe you'll make some changes. I actually have reviewed estate plans as old as 15 years, and there was nothing wrong with it. It may have even been older than 15 years, but there just was nothing wrong with it. I didn't see any need to make any changes. The people were still the different individuals that this person wanted to receive their assets, that they wanted to have making decisions about their assets. And so my advice to them was, great, I think you're in a good position. I wouldn't recommend making changes for the sake of making changes, because, you know, even though estate planning is affordable, we don't need to be going and making changes willy-nilly and subjecting ourselves to those costs if we don't need to. Maybe you just want to have a better understanding of your plan or of estate planning in general. And I often hear this from people who have worked with an attorney in the past, is they worked with an attorney, but the attorney kind of just pushed them along the trail, and they aren't exactly sure what their estate plan says or what it means or what, you know, any of this stuff means. They just know that they have had an estate plan done, but they're not really comfortable with it. And today I am here to give you information and to give you knowledge. I want you to have the power. I want you to have the understanding over this topic so that you know what it is that you want and you can get what it is that you want. And post in the chat, again, if you have a specific question here today, or post in the Q&A. I'm happy to answer questions, as you can see. And if you have a question, it's likely that someone else here in the room or here in the webinar also has the same question. And I promise I won't make you stand up in front of the class or anything like that. That brings up another question. I can't see you, I can't hear you. And so don't, if you're cursing at me as you're watching me, that's okay. I can't hear or see you. Well, you're probably weirded out if you're cursing at me and I just called you out for it, even though I can't hear you or see you. That must be a weird situation for you. I don't know if that's actually happening. Okay. Anyway, I want you to know whether you have an estate plan in place or not, whether you think it's too expensive or whether you're too busy or whether you're too young. I want you to know that you're in the right place here tonight. You're in the right place if you have someone or something that you care about and that you want to protect. You're in the right place if you've done an online will or a do-it-yourself will, and you're not sure if it's going to work for you, or you're considering doing something like an online will or do-it-yourself will. Maybe you have that Susie Orman will package or trust package sitting on your bookshelf right now. I've helped clients in that very situation that just couldn't get it done. They just couldn't get the estate plan done from that Susie Orman Susie. Oh, now I'm second guessing myself, Susie Ortman box. That's okay. You're in the right place here tonight. And you're in the right place if you're nervous about how much this is going to cost. And that's information that I think you deserve too. What is this going to cost? And I'm going to spend some time at the end telling you exactly what you can expect an attorney to charge you to write a custom tailored estate plan that's going to take care of the people that you love. Whatever the case, I'm glad that you're here with me tonight, and I hope you'll bring me your questions as you think of them. The reality is estate planning isn't about us. It's about the people that we love. And this is something that really became clear to my wife and I when we were updating our estate plan recently. These are 3 of my 4 children. I haven't had this picture updated. There's a picture of our 4th later in the slideshow here. But that's who we were doing our estate plan for. And it wasn't necessarily to, it wasn't going to bring us extra money. It wasn't going to put a new roof on our house or anything like that. But it was there to make sure that those kids were well taken care of and that they were going to be with people who love them, that they were going to have the resources available to them that we wanted them to have to raise them and to make them flourish and to release into the world as adults that we're doing well. The reality is your loved ones are going to know whether you lived up to your promise to take care of it, because they're going to be the ones living through it at a scary time, at a difficult time, a time when they're grieving you. So here are the things that we're going to talk about today. We're going to talk about planning for incapacity and some of the documents. In fact, I'm going to launch one final poll here just to see a little bit about your demographics and about the people that we have here today, if you don't mind answering that for me. We're going to talk about planning for incapacity, a couple of documents there. Healthcare directive and power of attorney. We'll talk about those documents and how they enable people to make healthcare decisions for you and financial decisions for you. We'll also talk about planning for when you pass away. And if you have minor children, and I'm seeing at least one person here who has young kids, although most people it looks like have grown kids or no kids at all. But I do see at least somebody with young kids here. Then we also want to plan for guardianship. And we want to make sure that those young kids are taken care of, that they're in the care of somebody who is going to take care of them after you're gone, if something happens and you're gone. We'll talk about probate, and we'll talk about the time, cost, and public nature of probate and why so many people choose to avoid probate if possible. We'll talk about, and it is possible, by the way. Talk about estate taxes, we'll talk about unclaimed property, and we'll talk about intangible assets, things like your values and your stories, and how you can share those with the people that you love as well. Oh, skipped right past it. But before I do, let me tell you just a little bit about myself. I promise we're getting into it, we're close. This is my family. Now we live in Bloomington, Minnesota, or West Bloomington, as prestigious West Bloomington as so many people know it. But yeah, we live in Bloomington, Minnesota. My wife's name is Tobin. My kids are Ben, who is 11 years old, Elizabeth, all the way on the left here, who is 8 years old, Margaret kissing the baby, she's 6, and then the baby is Bridget, and Bridget has just turned 1 year old. I graduated from the University of St. Thomas School of Law in 2012, near the top of my class, and the very next day, the day after my commencement, my son was born. After law school, I found a job with a small estate planning and tax preparation law firm, and I loved the clients that I was able to work with. At the same time, I didn't always feel like I was able to deliver the value that my clients deserved. And so a little more than 3 years after I joined that law firm, I ended up leaving. And this is actually a picture of my last day there. Someone asked to graduate at the bottom of the class. Now, this was not said about me. I just want to make that clear right from the start. This was actually said about another estate planning attorney that somebody had worked with, and they were struggling with the plan that this person had put in place. And there was a big reason for that. I actually don't think it was this attorney's knowledge or intellect or wisdom or anything like that. I think it was the faulty model that this attorney was practicing under. I call it planning for death, or the traditional estate planning model. Not that there's anything wrong with tradition, of course, but I'll talk a little bit more about that faulty model later. But first, let's get into some of the aspects of estate planning. And I want to thank everybody for sharing the demographic information with me. Because we have so few people here with young kids, I'm going to kind of speed through some of this guardianship information so that we can get to things that are relevant for everybody. But I want you to keep this in mind in case you know somebody who has young kids. If some of your kids have young kids, or if you have neighbors or family, friends that have young kids, this is really important. And it's talking about things like guardianship. And in guardianship, you want to have two forms of guardianship. There's something called immediate or short-term guardianship, and then there's long-term guardianship. Short-term guardianship is let's say that the kids are with a babysitter, you don't have a plan in place, something happens and you don't make it home that night. What's going to happen? Well, eventually that babysitter is going to call the police, that the police are going to bring in child protective services, and your kids for a time are going to have to stay in that child protective service situation. And I can tell you, it's not a dig at child protective services. I think they're doing the best they can with the resources that they have. But I never want any of my kids to have to spend any time with child protective services. And that's why short-term guardianship is so important. It's somebody who can stay with the kids in the near term. They have documents that prove that they're the ones who get to stay with the kids and take ownership and take guardianship of them until the long-term guardians can be identified or reached and actually come to collect the kids. So that short-term guardianship is somebody who can take the kids within 30 minutes and keep them at least a week until the long-term guardians can come and pick up the kids. Long-term guardianship, that's who's going to raise the kids until the age of 18. And the reality is, if there isn't a plan in place, the plan is this: a judge is going to decide. The judge is going to decide what's in the best interest of the kids. And that means if Uncle Larry out there, and I had a client who didn't want me calling him Uncle Larry anymore. Let's call him Uncle Brian. If Uncle Brian doesn't, maybe Uncle Brian is not the right person to take the kids, right? Uncle Brian is a problem, and he's not very nice to the kids, and he doesn't raise the kids in the way that that they need to be raised, and they need to be disciplined, and they need to be encouraged in their life. But unfortunately, Uncle Brian has a home and he has a steady job. And so to the judge, Uncle Brian looks like the ideal person to take the kids. And that's where the judge is going to put those kids. But it doesn't have to be that way. You can nominate guardians. You can get this information in place and make sure that your kids are taken care of by the people that you know and that you trust have their best interest in mind and will take care of them. I see here, does the guardianship for younger children apply to disabled adult children? And that's a fantastic question. A parent of an older disabled child who has guardianship over that child can choose guardians for that child, can choose successor guardians for that child. And there's a process for them to do that. And yes, I would absolutely say that it applies the same way, that you want somebody who can be there in the short term, somebody who can make the transition as gentle and as soft as possible. And then you want to name people for the long term, where again, that adult child is going to thrive and going to flourish as much as possible in a difficult situation. So I would absolutely say it applies just as much for disabled adult children as it does for minor children. That's a fantastic question. Okay, That's all I'm going to say about guardianship. If anyone else has any questions, I encourage you to bring them to me. And if this isn't a forum where you feel comfortable bringing me the questions, that's okay. Again, I'm going to have some opportunities for you to reach out to me after the meeting and ask me those questions, and we can get more specific about your situation in those separate conversations as well. Now I really want to turn and spend some time and attention talking about your assets and talking about how the people that you love are going to receive the assets that you have and that you want them to receive. And if you don't have a plan in place, or if you've been planning with a will-based estate plan, then there is a plan for you and for your assets. And that plan is called probate. And probate is the process during which your assets are transferred to your heirs after your death. There are a few things that drive people crazy about probate. Number one, probate is slow. In Minnesota, it takes a minimum of 6 to 12 months. More often, it's taking something like 12 to 18 months. We'd like it to go faster, but it just can't. It just isn't able to go any faster. There are built-in waiting periods for creditors. There's a 4-month waiting period for creditors. There are built-in delays where you're waiting to hear back from the probate court, or you're waiting to hear back from the registrar or the judge. There are built-in delays all over the place, as well as notices that have to go to the commissioner of DHS to see if there's any kind of estate recovery out there. Even if it's a young person, we still want to see if there's any kind of estate recovery that the state is expecting before distributions are made or before the house is sold or any of these things. It's a very slow and frustrating process to go through. And it's also very costly. We estimate that here in Minnesota, probate costs something like 3 to 6% of the gross value of the estate. It actually used to be tied to a statutory rate. I believe that was in Minnesota, and it still, I believe, is in some other states. But here in Minnesota, we don't have anything quite like that. We just have an estimate because it's composed of a variety of different fees and charges and expenses that you might face, or that your probate or your estate might face as it's going through the process. Things like attorney's fees. And I can tell you, I charge a minimum of $6,000 to bring a probate through the probate process, or to bring an estate through the probate process. It's expensive and it takes me a lot of time, and it takes me a lot of energy, and it's energy that I have to focus there and I can't focus on other things. And so I have to charge kind of an expensive rate for it, but my rate is well within line of other attorneys. In fact, it may be on the cheaper side of what other attorneys are charging for the probate process. In addition, there's executor's fees or personal representative fees. Not every executor or personal representative will charge a fee, especially if they're the only beneficiary or one of the only beneficiaries, but the executor is entitled to charge a fee. They're entitled to charge reasonable fees for their work. And regardless of whether they're choosing to charge fees or not, they are giving up their time to do that work. And it takes them a lot of time and a lot of energy, and it eats into the other work that they can do or the other things that they can be doing to enjoy their time. There are appraisers' fees and filing fees. There are creditors out there that need to be paid, and there's a potential for bond and bond premiums. It's expensive, and we'll actually have a chance to calculate your probate cost, or what your probate cost, what your estate might cost to go through probate here in just a little bit with some back of the envelope math. Probate's also public. So I'm showing you here the last will and testament of Anna Nicole Smith. And I can show you this not because it leaked on the internet or anything like that, but because wills are totally public. The court system is a public system. We want to have transparency. We want everything to be out in the open. But a lot of people don't realize this, that there are other things that are out in the open and that are made public as well, things that maybe should be private, things like a will that says who is going to receive your assets. And not just that, there's something that's filed called an inventory of assets that lists exactly what assets you have. And then there's a final distribution plan that says exactly who's going to receive those assets. In fact, you can see this information. I live, again, here in Minnesota, and I'm seeing some people from Plymouth. I'm seeing people from Minnesota, Waconia. And again, our friend from Alaska is joining us as well. Here in Minnesota, we know Prince. Right? I told you, I grew up in Chanhassen, really close to Paisley Palace and Paisley Park, Paisley Palace. I can't even anymore. It's been too long. But we knew Prince, and we knew when Prince was in town. We saw his limo driving around and all these things. We ran into him at the baseball fields, all that stuff. Well, Prince died. It's probably be like 6 years now, and his probate has I think just finally resolved. But you can find out all that information. You can access all that information through the Carver County District Court. It's all public. His half siblings, how they're receiving, the way that it's going into separate businesses, and the businesses are giving certain percentages to certain half siblings of Prince. It's all public. The numbers, the exact amounts that those people are receiving. It seems crazy, but that's the court system. That's probate. We want things to be transparent. We want things to be public. And that's a scary thought right now. It's a scary thought with as many predators are out there, as many people who are looking to earn a quick buck from somebody who doesn't have the financial sense to deal with the assets that they're dealing with. It's unnerving to know that all of that information is public. If you have minor kids, those kids stand to receive all of your assets at the age of 18 and completely unprotected. And I think we all know stories where people received assets at too young of an age, and it affected their financial sense. It affected their ability to deal with money and their ability to buckle down and work hard. It's not something that you want to have happen. It's not something that you want done in your family. I can assure you that. And I just really encourage you, for no other reason, planning for your children, or planning for grandchildren, planning for nieces and nephews, whoever you're planning to leave your assets to, make sure that you're leaving those assets in a way where they are old enough to handle the assets when they do receive them. All right, here's our chance to calculate our probate estate. Here you can say I have assets that typically go through probate. Things that typically don't go through probate, that's an easier list to create. Things like retirement accounts and life insurance policies often will have beneficiaries listed on them, but these things generally don't. Things like the family home, rental property, furniture and household goods, automobiles, stock, bonds, bank accounts, business interests, these things almost never have beneficiaries listed on them. It's not impossible to list beneficiaries on some of these things, but in fact, with transfer on death deeds, it's possible to list it on real estate. Automobiles actually have a TOD that you can put on your title so that it transfers at your death. Bank accounts, you can list TOD, which is transfer on death, or POD, which is pay on death, on those bank accounts. And business interests, we actually have a statute here in Minnesota that permits transfer on death designations on your business interests, on things like a stock certificate that you hold or a membership in an LLC, kind of interestingly. But I almost never see these things done when people first come in and meet with me. Almost always, everything is just going to be subject to probate, and now we need to figure out how we can avoid it. So this is a sample. You can line up your assets based on this. Again, don't include things like retirement accounts and life insurance policies, because those generally pass by beneficiary designation, but just include these types of assets here. And once you've totaled those assets, you can take 5% of the gross estate as a calculation of what the costs and fees might be by moving the comma over one place, and that gives you 10%, and then cutting the number in half. And that's how I got this number here, $42,500 on an $850,000 estate. And this might even be low because there are two parcels of real estate that are going to need utilities continually paid on them, mortgage continually paid on them. Something like a business interest is very difficult to convey, to transfer. And oftentimes there can be a lot of interruption and lost customers, lost client, lost goodwill in the transfer of a business if it's going through the probate process, because it takes so long and because it's so disruptive to operating that business. But this gives you a possible estimated probate costs and fees. You can imagine how expensive your probate might be. If you add a little hiccup to this, if you have life insurance proceeds or retirement accounts that are payable to a minor, well, those monies can't go directly to a minor. Somebody under the age of 18 can't take that kind of money, can't accept that kind of money. So instead, it needs to go through a process called conservatorship. And conservatorship is even more expensive than probate. It starts with a system similar to probate, But then it gets into annual filings, annual reportings that conservator needs to make to the court about how they've been using the money and where the money currently is. And it gets to be very cumbersome, very time consuming, very expensive to have a conservator over those assets. And it adds to this cost here so that you can see what the estimated cost of a probate and conservatorship would be if you had some life insurance and retirement accounts payable to a minor. There is a way to avoid probate. I told you that at the beginning, and I'm telling you again now. In fact, there's a foolproof way to avoid probate, and that's by fully funding what's called a living trust or a revocable trust. And the simplest version of what a living trust or revocable trust is, this is the simplest demonstration I found, is this: that you start with some property and you give that property to someone else. And you say, that's not a gift that I'm giving you. It's not like I am relinquishing all rights to that. I'm giving you that property to do something with it. And here's what I want you to do with it. And then this person says, I understand. I'm taking this property, but I understand that it's still yours. And I'm going to do as you've asked with this property. This person is called the settler. It's the person who creates the trust. This person is called the trustee. They're the person who hold and control the assets and are going to take care of the assets for you. That's the simplest version of a trust agreement that I've been able to find. Settler starts with property. They give it to a trustee. They say, this is what I want you to do with it. The trustee agrees and says, yes, I promise to use the property the way that you asked me to. They're holding the property in trust now. It's an agreement between these parties. And it's possible to do this with all of your assets, with things like investment accounts. You go to the brokerage, you go to the bank or the financial institution, and you actually retitle the account. So now it's in the name of your trustee, okay? That your trustee is now holding on to it. And I should point out, with a living trust or a revocable trust, almost always, you are this person, the settler. You're also this person, the trustee who's holding on to the assets. You're just wearing a different hat at that point. You're wearing the hat of a fiduciary, somebody who's controlling the assets then. You're also the person with complete right to benefit from the trust, which means that you get to use the assets in the trust for whatever you choose to use them for. You can go and buy groceries with them. You can go and buy a Tesla with them. They're your assets still. You get to use them for whatever you want. But again, back to this example, you go to the financial institution, you retitle your investment accounts, so now they're in the name of the trust and they're no longer in your personal name. They're no longer subject to probate like the assets in your personal name are. Now, when something happens to you, you're no longer trustee, and your successor trustee is just going to step into your shoes, promise to follow the same rules that you had written earlier, and those rules are now irrevocable. It's become an irrevocable trust at that point. And then they just carry out your wishes, your wills, new beneficiaries, and they're just taking care of things in that way. Same thing with bank accounts. You go down and sign new signature cards, and that puts them in the name of your trust. You execute deeds to real property. So now the property isn't in your name as a settler anymore. Now it's in the name of your trust, and your trust is holding on to that property instead of you in your personal name. Stock and bond certificates. Personal property, you can assign it using a document called an assignment of personal property. Life insurance and retirement accounts go into your trust at your death by beneficiary designation and not before that, because you have to keep those in your personal name during your lifetime. Not necessarily, life insurance can be in a separate trust, but usually it's not. Usually it's held in your personal name and then it transfers at your death into the trust. I have a question here. Does this mean the trust has to file taxes? And that's a fantastic question. A revocable living trust during the lifetime of the settler or the lifetime of the grantor, it's often called a grantor trust or an inter vivos trust, but during the life of the grantor, the settler, the person who created the trust, that trust does not need to file a separate tax return. It just is reported on your 1040, just like normal. After the settler passes away, after the original creator of the trust passes away, then yes, there is a trust return that needs to be filed. It's a 1041 return, which is a fiduciary income tax return. And at that point, because the trust has become irrevocable, because it can no longer be revoked, it needs to report income. And then that income that it's reporting generally ends up being passed through to the beneficiaries where it hits their 1040, their personal income tax return, instead of staying in the 1041, staying in the trust. Okay, so that's a great question. And the answer really is the trust will have to file a tax return after you're gone for as long as it remains in existence, but not during your lifetime. During your lifetime, you don't need to file tax returns, separate tax returns for the trust. At least that's the case in Minnesota. I can't see it being different anywhere else because it's, you know, it's federal law as well as state law here in Minnesota. So that's a trust. I imagine that there will be other questions about trust, and I encourage you to bring them, but that's the only question that I see right now. Now I get to give everybody some good news. I get to give everybody some news about estate taxes and about what are called exemptions. And right now, there are estate taxes on the federal level. There's also an estate tax here in Minnesota. On the federal level, the estate tax can get quite expensive, up to 40% or 40 cents on the dollar for everything that you're trying to pass on to your heirs or the people that you love. But the good news is on the federal level, you actually don't, that tax rate, any tax at all, the first dollar isn't even taxed until you get in excess of $12.9 million. And in fact, if you're married, you actually get to double that number. So it's over $25 million. It's extraordinarily high before you have to pay any estate tax on the federal level. And most people, you know, it applies to 0.01% or something like that of the people in the United States. Certainly, if you're close to that number, reach out to me, reach out to an estate planning attorney, because it is something that you want to plan for. The rates get extraordinarily high, extraordinarily quickly, and there are ways to plan for it, and there are ways to pass assets without having it be subject to that estate tax. Here in Minnesota, we have a lower estate tax exemption, and we have a lower estate tax rate. The rate kicks in at 13% and goes up to 16%. But again, we have an exemption amount of $3 million this time. And $3 million, again, is in excess of what most people have. Most people do not have a $3 million estate that they're looking at passing on to their beneficiaries, to the people that they love. It's something less than that. And so it's something that we plan for, and it's something that is always in flux. It's not consistent. Sometimes the estate tax exemption amount changes. Sometimes what applies in an estate tax changes. So we always monitor it, but just know that for most people here in Minnesota, for most people across the country, they're not, their estates are small enough that they're not technically, or they're not currently subject to an estate tax. They wouldn't currently be subject to an estate tax, but they might be in the future, and it's something definitely to monitor. So a little bit of good news for most of us. If you, in Minnesota, we don't get to double that $3 million number automatically, but there is some planning that we can do to double that number if you do some estate planning. And it's really important to do that estate planning to make sure that we get to double that number. Another question here. So once the trust becomes irrevocable, how can then pass to the next generation? And that's my understanding of that question is after you die and it becomes irrevocable, how does it pass to the next generation? How does it pass to the people that you want to receive it? And the answer is you list beneficiaries in that trust. You give orders to your trustee that after my death, here's what I want you to do with the assets. Here are the new beneficiaries that you have to report to and that you are going to be making distributions to. And those orders, again, are orders that your trustee is going to follow because they have control of your assets and they've promised to follow those orders that you've given in your trust. And so now that it's irrevocable, they're going to follow those orders and give the money to the second generation, the second generation, to the beneficiaries that you've listed in your trust when it was revocable. Okay. Here's something to think about. Does anyone have any idea how much money is currently in the Minnesota Department of Unclaimed Property? And it's over $700 million. And across the United States, that number is something like $58 billion, billion with a B. And the way that the money often gets there is somebody passes away, and the heirs and the people who are there collecting the assets are trying to collect everything, but they miss some things. They miss a bank account here, they miss some stock here, they miss dividends that weren't collected, or a check got tossed with the mail or something like that. Something gets missed. and becomes unclaimed. And now, in order to actually request that money and receive that money, it becomes very difficult. It becomes very hard to get it out of Minnesota Department of Unclaimed Property at that point. It's much easier if you can make sure that everything passes to your heirs immediately, and that they're aware of where everything is so that it can all be collected. And I see there's an extension on that last question. I mean, a generation after that. So parent to child to grandchild. Yeah, that's a great question. Oftentimes, things will go outright to the first generation to receive. So it will go outright to the children at some point, either immediately or in what's often called ages and stages. And so that means that they might receive a third at 25, a third at 30, and a third at 35. But oftentimes it's paid out before it gets to the grandchildren's level. Not always, though. There are some good reasons to keep things in a trust for the children their entire life and have it go then to the grandchildren in a special way. That's actually what this slide is about. There is some asset protection you can build into the inheritance to protect the money from things like a divorcing spouse or like a creditor in a bankruptcy, by keeping it in trust during their lifetime, allowing them some access to it and allowing them some discretion about what the money is used for, but ultimately protecting that money and keeping it shielded so that it can be available then to the successive generation, to the grandchildren, even down to the great grandchildren, depending on how you have written that trust. So that's a great question. And then it's up to you how that successive generation is going to receive it. Again, oftentimes people have it going outright to that successive generation. In fact, depending on when you're writing your trust, it may be necessary to do that because we have some rules against maintaining permanent or perpetual trusts here in Minnesota. There are some states with more friendly laws, places like South Dakota and Nevada, and even our friend from Alaska would be happy to know. I think that they have some more friendly laws about revocable trusts as well. But we don't really like perpetual trusts here in Minnesota. And so it can be difficult to keep things in trust, not just for your child's lifetime, but also for your grandchild's lifetime and your great-grandchild's lifetime. At some point, the state wants to see that money distributed. They want to see it go out to the grandkids or to the great-grandkids. But there are ways to build in some protection over successive generations, for the successive generations as well. If you have an irrevocable trust and the names would be in ours and our children, what happens if later on you would decide to sell your home? What happens? How does this work? What is the best way to protect our assets? That's a fantastic question. Oftentimes people I don't want to get too into the weeds with the Medicaid Asset Protection Trust or the irrevocable trust. Again, the trust that I was talking about before is a trust that is revocable, that is amendable during your lifetime. You can make changes to it. There is this Medicaid Asset Protection Trust or irrevocable trust or 5-year trust. It goes by lots of names, but essentially it's an irrevocable trust that's on rails at that point and is set to just do what it was pointed to do at the beginning. And that means that the beneficiaries are difficult to change, the trustees are difficult to change, and it's not you anymore. And it's like you've given your house away at that point. However, there are things that we can build in there. If you have a lot of trust in your children, if you have a lot of trust in your family, we can have the kids receive and be the beneficiaries on that irrevocable trust. And then if they see mom and dad need some help, they need some assets, well, they can eventually, if you're in a nursing home, sell the house, keep the assets in that irrevocable trust to some extent, and maybe make some distributions to offset some of their costs in providing care to you and helping you out. That there are ways for them to do that, that they can use some of your assets to make other assets of theirs more accessible and make sure that you're still taken care of. It's a difficult question, frankly. What's the best way to protect our assets is an extraordinarily difficult question. It's one that's also almost impossible to answer unless you're aware of all of the tools that are available. And that's why I really encourage you to reach out to me and come and meet with me and we can look at the specifics of your situation, and I can guide you through the different tools that we have available and the things that you want to achieve, the goals that you have, and we can find the best way possible to protect your assets and protect your family and make sure that you are achieving the goals that you want to achieve. Okay. All right. An estate plan also plans for incapacity. And pictured here, this is Terry Schiavo, and some of us may remember the story of Terry Schiavo. She suffered a cardiac event and went into a vegetative state. And her parents and her husband argued and weren't sure about what kind of care Terry should be given, whether life support should be continued or not. That the husband wanted to stop life support, but the parents wanted to continue life support and believe that Terry was still there, was still interacting with them and interacting with her world. There were a lot of court cases that this spawned, going all the way up to the Supreme Court, and eventually it was decided that Terry Schiavo's life support would be turned off, and she ended up dying about a week after, I believe it was about a week after her life support was turned off. It's a very tragic case. There was a lot of conflict. There was a lot of fighting in that family, and it led to a lot of fighting in the courts and a lot of fighting in families across the nation afterwards. But it didn't have to be that way. That we can make decisions about our healthcare. We can make decisions about what we want for our healthcare, and make sure that those decisions are secure in something like a healthcare directive, guiding our healthcare agent to the decisions that we want to have made on our behalf if we're ever in that kind of coma or a vegetative state type of situation. We've talked about a lot of things tonight. We've talked about probate. We've talked about guardianship for minor kids. Talked a little bit about estate taxes. We've talked about asset protection, and we've talked about how we can do that through irrevocable trust and how we can definitely do it for an inheritance. We've talked about incapacity planning and planning for incapacity. And my guess is something here tonight probably resonated with you. Something here you probably said, yes, I am aware that I'm not going to live forever, and that someday my kids or my nieces and nephews or my friends are going to inherit my assets, and I don't want them to have to go through probate. I don't want them to have that time, that attention, that all those resources pouring into probate. That's not what I want for the people that I love. Or maybe it was guardianship. Maybe you're the one of the families here with young kids today, and you're saying, gosh, I don't want our kids to go and have to spend time with Child Protective Services. Or I don't want Uncle Brian to be the one who takes the kids in the situation where it can't be decided where the kids are going to go and a judge needs to decide. Or maybe it's that incapacity planning, and you're saying, I don't want somebody else making healthcare decisions for me. I want to be the one to make those healthcare decisions, and I want to do it now when I have capacity to do it, so that in the future, if I don't have the capacity, well, my healthcare providers and my healthcare agent can just follow the orders as I've laid them out. Whatever the case, whatever's resonating with you, you have a couple of options right now about how you plan. You can either try to put in place a do-it-yourself plan, or you can work with a lawyer. And keep in mind, not all lawyers are the same, and I'll talk more about that. But for that first question, should you do it yourself? Well, here's what I say. And keep in mind, I'm an interested party. There's no question about that. I'm an estate planning attorney. This is what I do for a living. But I can tell you, I have worked with a lot of families who tried to do it themselves on an estate plan. I've worked with families who've tried to do a transfer on death deed themselves and made mistakes, and it didn't work the way that they wanted it to. In fact, that seems to be a very big problem, is that either the transfer on death deed gets executed and never gets recorded. I've had that come into my office more times than I care to admit. It's been an ongoing refrain. I've seen transfer on death deeds with the wrong legal address on it, and so it wasn't clear what property was supposed to transfer. In fact, it was referencing a property that didn't exist. Now what? What is the court going to do with that? What is the recorder going to do with that? And how can we actually transfer title when we have a transfer on death deed that's referencing the wrong property. I've had wills that are so outdated, they don't list successive children that have been born. I've had wills that name an executor who should not be anywhere near the estate because of decisions that that executor has made in the person's life later on. There are a lot of ways that it can go wrong. Trying to do it yourself, trying to rely on an old plan or just a do-it-yourself plan. But these are some particularly identifiable things that I've noticed is if you have more than just your personal belongings, if you have more than just your cars and clothing, jewelry, and furnishings, for example, if you own real estate, if you own significant assets in a bank account or a retirement account, you're probably going to want to work with a lawyer to make sure that that gets transferred the correct way. If you want to ensure that the people that you love stay out of court and conflict, and that they have an agent, that they have somebody that they can turn to when something happens to you, then you definitely want to work with an attorney. If you want the kids protection plan, which includes the immediate guardianship and the long-term guardianship, or you want to avoid probate or estate taxes, or you want to protect your children's or your nieces and nephews' inheritance, then you have to work with a lawyer. Those are things that only a lawyer can provide. If you want to guarantee that your plan is going to work when your family needs it to work, then you want to work with a lawyer. And I always give this example. I was going to take my son fishing, and we had ordered a couple of new rods and reels, and I needed to put fishing line on those rods and reels. And I waited until the morning of, thought that I could just get it done quickly. And so I did. I worked on it that morning, and I wound the fishing line on. And just when I thought that I was done, I went to clip the fishing line, and I don't know what I did wrong. Still to this day, I haven't had somebody tell me something went wrong, and all of a sudden the fishing line just started jumping off of the reel and going everywhere. And I had this absolute tangled mess of fishing line on the table in front of me. That was an example of a do-it-yourself situation that had gone wrong. But that's okay. You know, at the end of the day, it was a do-it-yourself situation. I had a mess of fishing line on my hands, but I was able to clip the fishing line at one point and get it figured out and get it straightened out so that I was able to use that fishing rod that day and take my son. Still was able to take him fishing as I had planned to. All I was out was maybe 10 cents or 30 cents in fishing line. It wasn't a huge expenditure. I was there. I was able to fix the problem right away. I was able to fix it quickly. You know, all of those things indicate that this was a do-it-yourself project that's not so bad to take on. The worst possible thing that could have happened if I would have somehow destroyed the fishing rod or destroyed the fishing reel, I would have been out maybe 50 bucks, $100 in that fishing rod and reel, right? An estate plan is the opposite way. An estate plan, you're not going to know if your estate plan is going to work until you're gone. You can't be the one who's putting the pieces back together, who's fixing it. And it's not simple like that. And it's not cheap like that. And I've been there and I've seen these issues. I've seen them go through probate. I've seen them go through other court procedures in order to get things fixed. And I can tell you, it's not cheap. It's not easy. It's not quick. It's not a situation that your family is going to be happy with. And that's why I really encourage with something like plumbing on an inside wall, or electricity that could fry you, something like an estate plan where there's a lot of expense, there's a lot of moving pieces, there's a lot of expertise. I really encourage you to consider hiring an attorney, bring on a professional, and have the help that you need to make sure that it's going to be done right. Just one added point, if you want to give your assets to someone other than your kids, I really encourage you to work with a lawyer to make that happen. Someone has to graduate at the bottom of the class. Again, not all attorneys are the same. Not all estate planning attorneys are the same. Typical experience of working with a typical estate planning attorney looks like this. There's form documents that are kind of set it and forget it type documents. And oftentimes clients will come in, and this again is not me. This quote wasn't said about me. I don't practice this way. But oftentimes clients will come into a typical estate planning attorney, and that typical estate planning attorney will just size that person up and put them into a plan. and there isn't a lot of conversation, there's not a lot of discussion. They will just put that person into some form documents that likely the client doesn't understand very well. They don't get to make a lot of decisions. They're not aware of really what's happening in their estate. It's just form documents that the attorney has kind of set them in. Oftentimes, it's not going to keep the money out of the Minnesota Department of Unclaimed Property because that's not where most estate planning attorneys put their time and attention and their focus. They think their only job is to prepare legal documents, and it's just not going to take care of things in the way that most people expect things to be taken care of. Typical experience may avoid probate, but it may not. In fact, the sad truth is a lot of estate planning attorneys practice probate as well. And it's actually to the advantage of some estate planning attorneys because they know if the estate plan doesn't work out and the client goes through probate, or they put them into an estate plan that's just a will-based plan and they know that they're planning for probate, they know that that client's probate is going to come to them because the family is going to reach out to the attorney who drafted the will, and they're going to have the extra work to bring that estate through probate. Let me tell you, I do probate, but I don't like it. The only reason that I do probate, and I haven't had to do probate for my clients, thank goodness, up till now. I do probate for other clients because I think it's important to have. It's an important way to see the other side of the system and to see what the consequences are for estate planning in a certain way. And so that's the reality of probate. Typical experience probably isn't going to keep the family out of conflict. It's just not something that most estate planning attorneys worry about or think about, family dynamics. Typical experience is only going to focus on money. It's not going to focus on your stories and your values, those intangible assets that are most commonly lost assets. It's going to leave assets to heirs unprotected without that asset protection that you can build into your inheritance. It's not going to include legal guidance because it's going to require hourly fees for your future needs. That's the most typical way that most estate planning attorneys charge, is by hourly fees and not on a fixed rate fee schedule. Typical experience is not going to adequately protect the kids. You may have the long-term guardianship nomination, but few do the short-term guardianship nomination or the immediate term guardianship nomination. And really, you're going to be left with this question: is my plan going to work when I need it to work? And that's not a question that anybody should have after they've worked with an attorney to write an estate plan. And that's why planning with me is totally different. I charge flat fees and I let my clients choose the fee based on some different packages that I have available. And I want you to choose the fee. I'm going to guide you to choose the best package for you, for your family, and achieving your goals in your estate plan, as well as balancing that against the finances that you have and what you have available to make that plan a reality. That I understand we're all on a budget. We're all, making ends meet. I'm not going to encourage you to write an overly expensive plan just for my sake. I want you to have an affordable plan, but one that's going to take care of your family in the right way. Planning with me keeps the money out of the hands of the state. I create an inventory for my clients to make sure that everything goes to the people they want to receive it, that nothing gets lost to the Minnesota Department of Unclaimed Property or any other state Department of Unclaimed Property. Planning with me protects the kids totally, both in the immediate and the long term. We do both guardianship nominations to make sure those guardians are always available. We do planning with me means keeping your family out of court and conflict. I think that that's so important. I've seen it in my family. I've seen it in other families. That difficulty, the conflict that can come out of a poorly written estate plan or an estate plan that doesn't consider what the family dynamics are. And I won't do it. We have to consider your family dynamics. We have to plan in a way that's going to minimize the conflict and make things as easy as possible for the people that you love after you're gone. Planning with me is going to mean that you know that you've made the right decisions, because I bring you along in the process. I educate you and I empower you to make the decisions at the right moments for your family so that you can make sure that your family is well cared for. Planning with me means protecting the family money from outsiders, from things like a divorcing spouse or things like a like a creditor in a bankruptcy. Planning with me, it means a lifetime of guidance and protection because there aren't ongoing hourly fees. You know that you have access to me by phone, by email, so that you can ask me your questions and get answers to those questions, even after we're done writing your plan. Your plan is going to work when your family needs it to work. And remember, this is really a gift that you're giving to the people that you love the most. So what should this cost? Well, keep in mind that planning this way will save your family at least $12,000 if all you have is a house worth $400,000. That is 3% of a $400,000 house. And I understand not all of us have a $400,000 house, but for those of us who do, 3%, $12,000 is on the very, very low range of what probate might cost your estate to go through. If you have assets over $3 million, this planning will save at least 13 cents for every dollar in excess of $3 million. That's the estate tax rate, kicks in at 13% at anything above $3 million. A typical death plan with a typical estate planning attorney is going to cost a minimum of $1,500. If they're doing it for any less, they're cutting so many corners, it almost can't even be considered an estate plan at that point. And keep in mind that planning with a typical estate planning attorney probably isn't going to keep your family out of court or conflict. It's not going to ensure that the assets aren't lost to the State Department of Unclaimed Property. It's only going to cover your money, not your kids' immediate care or your values, insights, stories, and experience, those most valuable intangible assets that are often the most lost assets. The alternative is planning with me. I'm a personal family lawyer. That means I'm part of a group of nationwide attorneys who have agreed to practice in a different way. You can learn exactly what your family needs. And again, you can choose your own fee. And that range is generally between $2,000 and $8,000. And I can tell you, if a trust sounds appealing to you, if that revocable trust option sounds appealing to you, those trust packages start at $4,000. And that's what most people pay, is something like $4,000 or $5,000 to get a great estate plan written that's going to take care of their family, avoid probate, and make sure that their loved ones are well cared for while they're grieving and while they're missing you. You know that your family is going to work when your family needs it to work. And I want to make this really, really easy for you. I want to offer you what's called a family wealth planning session. And the family wealth planning session is a 2-hour-long session with me where we will talk about your assets, we'll talk about your family, we'll talk about everything, and I can give you information on exactly what you need to know about what is going to happen right now, what the state thinks you want to have happen, what probate might look like for you, what your family's approach might look like, what your family is likely to go through after you're gone. That $750 gets you a 2-hour-long meeting with me. In the first hour, it's all about educating you. It's all about talking to you about this is what you can expect. This is what it would look like right now. This is where we can make some changes and improve things for you. That's the first hour is all education. The second hour is if you want to plan with me, we are going to write your plan in that second hour. And we are going to work together. We're going to work collaboratively, and I'm going to guide you through the process. With that education that I've given you in the first hour, I'm going to queue up some decisions for you to make about different things that you might care about and different concerns you might have about your estate plan and about your family after you're gone. And we'll talk about it together. We'll talk about how you can make the best decisions. I'll counsel you, I'll guide you, but they are your decisions to make because you know your family. That's your expertise. That's something that I don't have any expertise on. I have knowledge and I have information about the laws and I can bring that to you, but you need to bring the information about your family. You need to bring your decision-making power so that you can make those decisions in that second hour. Again, that's if you want to hire me. Otherwise, just have that first hour absolutely free where you can ask your questions, you can get information from me, and at least you'll have some peace of mind after that first hour. Additionally, if you do want to plan with me, I am willing to offer you $250 off the estate planning fees, the estate planning package of your choice, if you reserve your appointment before the end of the week. And you can see I just put in the chat the link to my calendar. You can go ahead and book that family wealth planning session with me. I can tell you, I don't believe that I have any more time available in May. I don't believe that I have any more time available in June. I'm currently booking out to July. And the reason for that is because I spend so much time, I spend so much attention and energy with each one of my clients that it takes time. And I only accept so many new clients, so many meetings of new clients in each month, because I know that it takes time and I know that it takes my attention and care to make sure that your estate plan is going to work the way that you want it to work. And that's why it can be difficult to think that we're not going to meet for a significant period of time. And so I want you to take a look and get the earliest time on my calendar that works in your schedule. And after you've done that, if you want to, go ahead and click through again and schedule 15 minutes, have a 15-minute phone consultation with me as well. And I really invite you to do that so that we can touch base between now and your family wealth planning session, that we can talk about anything that's really pressing, that's really on your mind, and I can help you to get moving in the right direction for your family wealth planning session so that it can really be a successful session where we are able to get the planning process moving and get it moving in a way that's going to take care of the people that you love as quickly as possible. These are some of the things that my clients say, and I can tell you, if you go on and take a look at my Google reviews, you'll see that they've changed a little bit. Still 5 stars, but now I'm up to 19 Google reviews. This was taken just a little bit ago. I don't do a lot of soliciting of Google reviews. It's just I have a lot of very happy clients. And these are some of the things that they say. I can't read them out loud because it's too embarrassing for me, but you can go ahead and read what they say. I do want to talk a little bit more about that family wealth planning session. Family wealth planning session can be totally virtual. We can meet together over Zoom and come together that way. It'd be great to see your face, but I don't always see people on the Zoom call, but it does help us to get acquainted a little bit. We'll talk about things together. We'll talk about who would be the person to collect everything for you. Is there somebody in your family who has that kind of personality? Is there somebody who's organized, who makes sure that the bills are always paid on time? And we'll talk about what would happen if you became incapacitated as well. Who would be the one to make decisions if you were in a coma? Who would you want making decisions? Oftentimes, if our mom is still alive, that's the person that we want making decisions for us. Obviously, most often it's our spouse first who would be making healthcare decisions for us. But moms have a special place in our lives that oftentimes it's our mom that we want making decisions about our person if something happens to us. We'll talk about what would probate look like for you. How much would it cost? How much time would it take? What county are you in? And what does the probate look like in that county currently? We'll also talk about estate taxes. We'll talk about whether you would currently owe estate taxes or if it's just something that we need to monitor and make sure if the exemption changes that you're alerted so that you can do some planning and make sure that you have the best possible position to plan for those estate taxes. We'll talk about how the people that you love will receive your assets after you're gone. We'll make sure that it is the people that you want receiving your assets, and we'll make sure that they're receiving those assets in a way the assets are going to be a benefit to them and help them to lead their best life. After the family wealth planning session, I confirm everything with a confirmation document. I start drafting your documents. You can have your documents signed in as little as 4 to 6 weeks after that family wealth planning session. In fact, in the family wealth planning session, we will actually schedule your signing meeting out together so we know exactly when we're going to be signing those documents together. And then it's just us working together to make sure that I have all the correct information to draft your documents, and that we're drafting those documents with the care and attention to your needs and your wants, so that your wishes are carried out. But it doesn't end there. We also have a third meeting together, which is called the Family Wealth Legacy Interview, where you get to share your stories and your values if you choose to. And if not, at least we get to review your beneficiary designations and we get to review your assets to make sure that they're held in your trust. Or if you're not doing a trust, that we have the transfer on death deed recorded, or we have beneficiary designations set up the way that you want them to be set up so that the people that you love are taken care of in the absolute best and the absolute right way. So what are your next steps here? Again, your next step is to schedule the free family wealth planning session with me. Again, at the minimum, you're going to get that free hour of education, that free hour to ask me your questions and get your answers to your specific situation. If you want to continue planning with me, great. We can use the second hour to actually write your estate plan together, and make great steps in getting your estate plan in place from that initial meeting. I also want to give you $250 again towards the plan of your choice. All you have to do is get on my book, and it doesn't have to be a family wealth planning session that's between now and Friday. There aren't any available. I'm telling you right now, I don't have any family wealth planning sessions. Again, I think the earliest ones that are available, I believe, are in July. But if you book that July family wealth planning session with me before the end of the week, before the end of the day on Saturday, I am very happy to give you $250 towards your plan. The reason that I do that is because this is a momentum thing, and you have started the momentum here tonight. You have gotten on the call with me and you've educated yourself about this topic, but I know that estate planning is often one of the last things on our to-do list. It's not something that we really like to think about, and we always feel like there's a tomorrow that we can get an estate plan done. But reality is it's a momentum thing, and it's very difficult to keep the momentum after you've lost it. That's why I want you to take this next step now. Get your family wealth planning session booked and find time for us to talk for 15 minutes between now and your family wealth planning session. That's why I have both of those linked at that link that I shared out to the chat earlier. I want you to book the family wealth planning session with me, and I want you to book 15 minutes so we can have an initial conversation before your family wealth planning session so that you know what to expect and so that I know a little bit more about you, and that we have full information before our meeting. A little bit of information about awards and memberships. I also want to take questions from you. I know I didn't get to as many of the questions from the phone calls earlier today, things like property in other countries, and a little bit more about adult guardianship and serving as a guardian, as I was hoping to, but I hope that you all took some great information from this. I will stay on here for just a minute if people have other questions that they're hoping to ask here today, just to see if there are any other questions. I'm not seeing anything come through. I'm seeing a thank you in the chat. I want to thank all of you for being here. Thank you very much. Excellent presentation. I enjoyed it. Wonderful. Thank you so much for being here as well. I really enjoy this stuff, and I really enjoy giving people this information. And I really appreciate you for taking the time out of your evening to be with me here tonight and to educate yourself. Seeing a question, when are we going to get this recording? And I'm going to try and send out the recording this evening. If it's not this evening, I try and upload it to YouTube, and then send out the link to YouTube. If it's not this evening, then you should have it early tomorrow. But I am going to try and get it out this evening here so that you can review it if you choose to. Again, thank you all so much for joining me here tonight. I really appreciated having you here. I appreciated the fantastic questions, and I hope that you'll reach out to me. I hope to hear from you soon, and I hope that we'll be able to have a meeting together to talk about you and to talk about your family. Have a great evening, everyone.